So it's Tuesday at 3:30, so I'm here for my weekly question and answer session. As usual, I have questions that I have gotten via email this week, and so I'll just go through these. If in the meantime any of you have any more questions, just ask in the chat, and I will try to answer them as they come up. Okay, first, I have George Arias. Do I really need to hire a criminal defense attorney to represent me if it isn't a really serious crime? So just like, I think I've had this question before, and the answer is, as I've said before, you always need an attorney when you are charged with a crime. I don't know what you mean when you say it isn't very serious, but whatever it is, a misdemeanor can lead to a criminal conviction, which would be a criminal record for life. So, George, even if you think it's not serious, it is a criminal case, and so you would indeed want a criminal defense attorney to handle that for you. Okay, next, Luke Coleman asks, what are some of the most important rights I have as an accused person? So that's kind of easy. The first right is to keep your mouth shut. In other words, the right to remain silent. The presumption of innocence. Various rights. The one that my clients always hurt themselves on is the right to remain silent. If you speak to the police, they are only trying to extract information from you that would help gain a conviction. When there is a criminal investigation there, they are not there to help clear you of the charges. Therefore, you should not talk to the police in a criminal investigation without your attorney present. There's no exception to this for me that I can think of in my head. You always want your attorney with you when you're going to speak to the police, so that you can know what questions you should or should not answer. I can tell you 98% of the time when people come to me and the police want to speak to them, the answer is no. There have been very few occasions where I would allow an interview, and of course I would be present, but it depends on the circumstances. Again, like I said, as an accused, you are only the accused. You are presumed innocent under our system of justice until and unless the state meets their burden of proof and proves your guilt beyond a reasonable doubt. Generally speaking, that's where we're at. Alyssa N. What should I expect to happen at my first court appearance? So, Alyssa, that's going to depend whether you're felony or misdemeanor. It's going to depend also which jurisdiction you're in. Here in Galveston County, you shouldn't expect much to happen. Your attorney should be there to answer docket for you. If not, because there are times we have multiple courts to be in, and I have to pick somewhere to start. For me, it's generally I start in felony because felony trumps misdemeanor. So if your attorney's not there when docket is called, you would just stand up and say present when they called your name, and you would sit back down. If your attorney is there during docket call, and if it's me, then I stand up and say present with counsel, and I point at you so that the judge knows you're here. But other than that, you shouldn't expect much. Depending upon when your first court date falls in relation to your arrest, I may or may not have discovery before your first court appearance. And so if I don't, on the first court appearance, I will ask the state for whatever they have at that point, even if it's something as small as the offense report. I need somewhere to start. And that's usually pretty easy. And in today's world where everything is electronic, I can usually ask for it there in court, and they can email it to me while we're in court. Other than that, I get a new setting, and we just reset to figure out what discovery I'm missing, what I want, any investigation I may want to do. And so I'll get a subsequent court date, and we'll come back for that. but typically a first court appearance is not very eventful. Sometimes if it is a case involving family violence or a victim that the state doesn't want you to have contact with, there will be some bond conditions dealt with before the court on your first court date, meaning bond conditions like you can't have contact with this person or you can't go to or near this person's residence. In some courts, if it's a drug offense, the judge will issue a bond condition making you start drug testing when you come to court. And so that could happen depending on which court you're in as well. But as far as your case, you shouldn't expect much on your very first court appearance. Okay, Kevin Boyd asks, what determines whether my case will go to trial? And there's a lot into that question. So it could be that I don't think the state has enough evidence to prove your guilt beyond a reasonable doubt. And so my recommendation to you is that we go to trial. It could be that we're so far apart on punishment that, you know, a simple example is you really want probation and you're legally eligible for probation, but the state will only offer time in a plea bargain. In that situation, we might end up going to trial. Obviously, sure, there are other alternatives, but that has been a trial issue in the past where our main focus was punishment. It is possible to avoid the trial and just do punishment in some circumstances, but a lot of times my attitude ends up being, if the state's not going to give me what I want, then they're going to have to earn it. I'm not going to lay down and just give them a guilty plea over a punishment issue if they're not going to work with me. What else could make your case go to trial? Well, you could. It's your constitutional right. No matter what I think, if you demand a jury trial, I'm going to give you a jury trial. It could also be there are what we call no offer cases. A lot of times this happens with murder cases. The state simply will not make an offer because of the seriousness of the offense, and so we have no choice but to go to trial. No offer cases can be other types of cases, not just murder. I've actually had it in a drug case before because the number of kilos. So there's any number of reasons why your case might go to trial, just like there's reasons your case wouldn't go to trial. All right, Carmen Frazier. If the police never read me my rights, can my attorney get the charges dismissed? I get this question a lot, or not necessarily the question, but someone calls me to tell me that I should be able to get their case dismissed because the officers never read them their rights when they were arrested. And I guess this comes from too much television. The police do not have to read you your rights to arrest you. The police have to read you your rights if they're going to interrogate you. So if you are the subject of an investigation and the police want to talk to you and try and get information from you or a confession from you, those type of things, then they have to read you your rights, which is Miranda. So they have to Mirandize you before they can try to get a statement from you. That does not mean if they see you commit a criminal offense, they have to read you your rights before they handcuff you. And like I said, we get this a lot. It's normal that people think I'm going to get off because they put the handcuffs on me and threw me in the patrol car and never read me my rights. Well, that's because it was an arrest, not an investigation. I hope that answers that for you, Carmen. Sandra Moha. Can the police arrest me without evidence of my guilt? I'm not sure, Sandra, that I understand your question. Chad, really? How good am I? You know how good I am. So I don't know what you mean, Sandra. Can the police arrest me without evidence of my guilt? I mean, I guess the simple answer is yes. It would depend on the circumstances, but people get arrested all the time because of what police officers believe, what other witnesses stated. You know, they don't have to have evidence that you're guilty to arrest you. Now, simply being arrested doesn't mean you'll be found guilty. So that, you know, the old adage, you can beat the rat, but you can't beat the ride. So just because you get arrested doesn't mean you're going to get convicted. You know, that's my job. The state will do the investigation and try to gather evidence of guilt. The police officers don't necessarily do any of that before effecting an arrest. The arrest could be based on a number of things. Like I said, someone else said you did something, any number of circumstances. But no, they don't have to have evidence just to arrest you. I mean, the easiest thing I can think of is, for instance, in a sexual assault case, whether it be an adult or a child, oftentimes there's no witness, just the person who was assaulted making the accusation. So they accuse you and the police arrest you, but the case still has to be built. So yes, the police can arrest you without evidence of your guilt. Mark Fisher: if the person who filed criminal charges against me does not want to go to court or continue with the case, will the charges be taken away? So the answer is most of the time. The Constitution guarantees you the right to confront your accuser. So if your accuser is not willing to present and face you and let you cross-examine them, then that would violate your constitutional rights, and the case cannot proceed forward. There are some exceptions, and it would be as if, you know, let's say the person was interviewed at the scene and there was, you know, a certain amount of emotion involved, and then we would have to have a hearing to determine whether or not that's admissible without having that person testify under certain evidentiary rules, but it's very rare. Most of the time, your right to confrontation is going to be the controlling factor. Okay, Hunter Hall: if I have a warrant for my arrest, will hiring a lawyer help me avoid jail? No. Hiring me, I can't make the warrant go away. So if a warrant has been issued for your arrest, the case doesn't become active until you've been arrested. Many times the case has not even been assigned to a court for me to try and talk to a prosecutor. If the case has not been opened yet, simply because it's a warrant, there's nothing I can do to avoid that initial jail visit. Now, depending upon the type of warrant, what we do a lot is you would contact me and say, I have a warrant, and it depend, you know, I'll find out if it's a felony or a misdemeanor, and then we'll set you up with a bonding company and have you do what we call a turnaround, meaning you go in with your bonding company with bond in hand, turn you in. You have to go in just for processing, and then you'll turn around and come out. Most of my clients report that that's about a 3-hour process. So, you know, I can help shorten the amount of time you're going to be in jail, but I cannot avoid the jail trip altogether, because what activates the case is you getting arrested on the warrant. Okay. Gary Bates: what happens if I can't afford the amount of bail set for me? Can a lawyer help it get reduced? Sure. We do bond reduction hearings almost on a weekly basis. We did one this morning. So it is oftentimes happens that a person can't afford the amount of bail that's set by the court. So we typically file a writ of habeas corpus seeking bail reduction. Simple, it's a motion to get your bail reduced. We have a hearing. We have to have someone testify, about your financial position or depending on who would post the bail, whether or not they've talked to a bonding company, what type of bail you could afford. We just go through that process seeking to get a bail reduction. The important part about hiring a lawyer who knows where they are is that I know, depending upon which court you fall in, I have some idea of the chances of getting that reduction or not getting a reduction, depending upon the charge and the particular court that you're in. But generally speaking, yes, we get bond reductions all the time. Now, what people do call sometimes and ask is they want to know if they can hire us just to do a bail reduction. I don't do that. Here in Galveston County, basically, if you're going to come onto a case, you're coming onto a case. Many years ago here in the county, there was a time when we could make an appearance just for bond reduction, but the county stopped that. And regardless of whether they allowed it, I wouldn't do that. If I'm coming on your case, I'm coming on your case. I'm not just coming in to try and help you get out of jail and then jump back off. If I'm going to defend you, I'm going to defend you. Okay, let me see. I have my girlfriend, funny Nick. Other than Chad at C&M Dirt Works checking on me and Nick playing about his girlfriend Scratch Cat, I don't see any questions in the chat. So I hope you guys have a great rest of your week, and I will see y'all next Tuesday.